I'm going to talk today about termination. The reason why I want to talk about termination because it's an issue that people find very easy to avoid, and it's one of those subjects that we address at some length in the Contract and Copyright Drafting Skills book, because if you don't address it in a contract at the beginning, you're going to pay the price later on, because one of the main reasons people look at a contract after the contract's been signed is because they've fallen out and they're looking for clauses to say what happens now. So the first thing that you need to do is think of termination clauses that are appropriate to your circumstances. And each circumstance may be wildly different. You may just want a few clauses or you may want a few pages. It depends. So the main thing is to understand that the grounds of termination are very different to the procedure that is used to bring the contract to an end. So if you have a number of grounds, and one of them, for example, is material breach, just because material breach has been committed doesn't mean that contract comes to an end. What that means is that you then trigger the procedure to be used because there's a material breach. So you may want to give the other side a period of time to remedy the situation, and if they can't, then you serve notice. But that serving of the notice and the time period that elapses after that notice is served is what brings the contract to an end, not the breach. Then you have to work out, well, what happens now? The contract has come to an end, but who owns, for example, copyright material that may have been generated during the course of the contract? Are there payments still that have to be made? Are there clauses in the contract that still survive after the contract has been terminated? And so for these reasons, in our view, it's critically important to make a decision before you sign a contract and say, is it appropriate to put forward very clearly drafted and very fair clauses that will be incorporated into the written contract, rather than wait to the end, not have addressed it, the circumstances arrive, and you say to yourself, why didn't we do that in the first place?